My name is Sam Scharff. I'm one of the co-organizers of this conference, and I'm here. I'm an MD PhD student at Hopkins, and I am chairing this panel with our really excellent panelists. Our panel is titled Overturning Convictions, Innocence Projects, and the Revision of American Values. So I'm going to introduce them in order of their presentation. So first, we're going to have Keith Findley speak. So Keith Findley is with the Wisconsin Innocence Project. He's an associate professor at the University of Wisconsin Law School, where he teaches evidence, wrongful convictions, and criminal procedure. In 1997, he co-founded the Wisconsin Innocence Project, where he served as co-director until the spring of 2017, when he assumed the role of senior advisor to the project. From 2009 to 2014, he served as president of the Innocence Network, an affiliation of nearly 70 innocence organizations throughout the world. Professor Findley's primary areas of expertise are in wrongful convictions, criminal law and procedure, and appellate advocacy. He has previously worked as an assistant state public defender in Wisconsin and has litigated hundreds of post-conviction and appellate cases at all levels of state and federal courts, including the U.S. Supreme Court. So our next speaker will be Kate Judson. Catherine is the SBS AHT, which are disease constructs that she will discuss more, litigation coordinator for the Wisconsin Innocence Project, where she coordinates strategic litigation efforts in science-dependent cases, trains lawyers, consults on medically complex cases, teaches law students, and engages in direct representation of clients who have been wrongfully convicted of child abuse and homicide. She previously served as the Innocence Network Shaken Baby Syndrome litigation fellow and as a trial attorney with the New Mexico Public Defender Department, where she specialized in cases involving complicated forensic evidence. She's spoken before the American Academy of Forensic Sciences, the Innocence Network, the National Association of Criminal Defense Lawyers, and other law schools and professional organizations on topics related to forensic science. Our third panelist who will be speaking is Michelle Nethercott, who is with the Maryland Innocence Project. So Michelle is the director of the University of Baltimore Innocence Project Clinic and is a graduate of Northeastern University Law School in Boston, Massachusetts. And over the years, she has represented numerous clients who were exonerated on the basis of post-conviction DNA testing and other forms of newly discovered evidence. She began her career as a trial attorney with the Office of the Public Defender for the state of Maryland in 1988, and has handled numerous felony trials, including several death penalty cases. Nethercott also created and ran a forensics division in the Office of the Public Defender in the early 1990s, and has served as the co-chair of the Forensics Committee of the National Association of Criminal Defense Lawyers. She is an expert on DNA and various other forms of scientific evidence, and has lectured around the country and published articles in NACDL's Champion on the topic. Nethercott currently teaches a seminar course on wrongful convictions in addition to her clinical teaching, and has previously taught in the post-conviction clinic at the University of Maryland School of Law. And rounding out our panel is Jarrett Adams, who's with the Innocence Project, as well as the organization Life After Justice. Jarrett is the co-founder of Life After Justice, which is a reentry program, and is a post-conviction litigation attorney with the Innocence Project in New York. Before practicing with the Innocence Project, Mr. Adams was wrongfully convicted of sexual assault at age 17 and was sentenced to 28 years in a maximum security prison. After serving nearly 10 years, Jarrett was exonerated with the assistance of the Wisconsin Innocence Project at the University of Wisconsin Law School. Upon his release, he began working full-time as an investigator with the Federal Defender Program for the Northern District of Illinois, where he was named Investigator of the Year for his work on the case of Reynolds Wintersmith, which led to Mr. Wintersmith's life sentence being commuted. Jarrett graduated from Loyola University Chicago Law School in May 2015, served a public interest fellowship with Judge Ann Claire Williams, the U.S. Circuit Court Judge for the U.S. Court of Appeals for the Seventh Circuit, and then with Judge Deborah Batts in the Southern District of New York. So we have some very thoughtful experts here for us today, and my job will be to stay out of their way. And we all look forward to hearing what you had to say. So thank you so much. We'll start with Keith.
Well, thank you, Sam, and thank you, all of you. This is really a privilege to be here as part of this really interesting program. My task here, I think, as the lead-off on this panel will be, in the brief moments that I have here to talk to you, will be to sort of set the stage for the rest of the panelists to address these questions about how the Innocence movement has helped revise American values and the challenges that the movement confronts in doing that. And I want to sort of position this discussion by suggesting to you that over the last 15, 20 years or so, we have seen ourselves come to a crossroads in criminal justice policy. And it's a crossroads where we see, for the first time in decades, at least the opportunity for a move from this very punitive culture and set of policies that we've lived with since the war on crime began. And this is not to say that we're there or that we don't have challenges, but that we have perhaps seen more opportunity for real movement in the last couple of decades than we had seen for a long time before that. And I think that there are two components of this that are in some ways interrelated. One is the problem of mass incarceration that I think you've been hearing a little bit about so far, and with discussions about rehabilitation as an alternative to the very punitive philosophy that has driven correctional policy and criminal justice policy for a long time. And much of this is driven by the fact that we have gotten ourselves into this mess with mass incarceration that both has fiscal costs that we cannot bear anymore, but also enormous human costs. And so it's this recognition has opened up an opportunity for perhaps re-examining where the system is going. The one we're going to talk about is the Innocence movement, which I think in many ways that probably have not been adequately recognized before. These are complementary. And the reason I suggest they're complementary is because the Innocence movement, it seems to me, for the first time in a couple of decades, allows us to recognize that the rush to judgment, the impulse to be highly punitive, has costs. And it has costs in terms of human suffering, costs in terms of wrongfully imprisoning innocent people, and the flip side of that is failing to convict the actual perpetrators. And this is what some in the literature have referred to as actually the Innocence Revolution, or even have called it a new civil rights movement. And so I think both of these features have allowed us to come to a point where there's at least an openness and a possibility for reform in the way that we dispense criminal justice in the world. And I say this because I want to juxtapose this against what was the prevailing norm or prevailing attitude in this country, represented by, we always used to hear we have the best criminal justice system in the world, spoken proudly by judges and prosecutors and defense lawyers, people who've probably never taken a glimpse at any other criminal justice system in the world nonetheless, but we said it nonetheless very proudly. And that was the attitude, and it was reflected for decades by attitudes like this very famous quote by Judge Learned Hand in United States versus Garcon, where he said, "Our dangers do not lie in too little tenderness to the accused. Our procedure has been always haunted." This is his famous quote, "Haunted by the ghost of the innocent man convicted. It is an unreal dream. What we need to fear is the archaic formalism and the watery sentiment that obstructs, delays, and defeats the prosecution of crime." That quote probably captures very, very well what had been the dominant attitudes. A few years later, this prosecutor in Massachusetts was famously quoted as saying, "Innocent men are never convicted. Don't worry about it. It's a physical impossibility." So you say, okay, that's from the 20s and 30s. Well, let's move forward. How about 1985? Remember Ed Meese? Attorney General Ed Meese? But the thing is, you don't have many suspects who are innocent of a crime. That's contradictory. If a person's innocent of crime, then he's not a suspect. That reflected very much the attitude in the war on crime. This was something that was reflected by academics as well. Stephen Markman and Paul Cassell. Paul Cassell went on to become a federal district court judge and is now a law professor at the University of Utah School of Law. They suggested that the risk of executing an innocent person is too small to be a significant factor in the debate over the death penalty. And the U.S. Supreme Court, Justice Sandra Day O'Connor, in her concurring opinion in Herrera versus Collins, says, "Our society has a high degree of confidence in its criminal trials, in no small part because the Constitution offers unparalleled protections against convicting the innocent." So that was the sort of really the prevailing attitude about criminal justice in this world until the late 1980s and the early 1990s. So this Justice O'Connor penned this just as the attitudes were beginning to change. And what do you think made those attitudes change? It was the development of forensic DNA technology, which came along in the late 1980s, right, and was just beginning to make its mark in the early 1990s. And pioneering lawyers like Barry Scheck and Peter Neufeld at the Innocence Project in New York recognized the potential for DNA to get to the truth in old cases where people had been in prison for a long time and had been wrongly convicted. To date, we now know of at least 351 people in the United States who've been exonerated by DNA testing alone. These are people who were convicted in the most heinous of crimes. 99% of them are rapes, murders, or rape murders. And the DNA cases are limited to that group of people, not because that's the only place where we make mistakes, but because those are the kind of cases where we typically have DNA, right? Which suggests that what's happening, that surely those kinds of things are happening in other kinds of cases where we don't have DNA as well. And in fact, there have been attempts to count other exonerations. The National Registry of Exonerations now has over 2,100 exonerations that they know about since 1989, based on all kinds of evidence. So the reality has changed that we now recognize that the system is fallible, that there are costs to the rush to judgment, and therefore the opportunity is there to try to implement some reforms. Where did this attitude that we're trying to overturn come from? Well, I think you have to look back to the last big revolution in the criminal justice world was the Warren Court's due process revolution, which occurred, of course, in the late 60s and early 70s. And that was where the United States Supreme Court adopted a due process approach to criminal justice and started extending a whole lot of protections to criminal defendants that had not been recognized before. And what you'll see, and this is just a partial list of some of the reforms that the Warren Court implemented. But what you'll notice is that this is very much a process-oriented approach to criminal justice. That is, it's not so much focusing on substantive justice. It's not so much focusing on do we have the right person, are we treating them fairly, but rather what kind of procedural protection should we implement. And some of these, you might say, are ones designed to help us get to the truth. But many of them seek to implement procedural protections for other values that actually can be in some ways truth-defeating. Things like exclusion of evidence based on Fourth Amendment searches. Well, the fruits of those Fourth Amendment searches are usually good, reliable evidence, but we suppress it, we exclude it nonetheless, because we are in service to other values about privacy and whatnot. And so it was because of this due process revolution that the war on crime started pushing back and saying, look, we're going too soft on criminals, we're letting people off too easily. And it was about that time in the late 60s that Herbert Packer came up with his very well-known competing models of criminal justice. He said, what we've got in criminal justice is two competing, very antithetical models, the due process model and the crime control model. And the due process model was sort of reflected in what the Warren Court was doing, which was saying, look, there's no legitimacy to the process till we go through formal processes with a lot of protections. The crime control model, on the other hand, was one that emphasized apprehending, trying, convicting, and sanctioning a lot of people really quickly with a minimum of procedural obstacles. It's what's reflected primarily by what has become the dominant form of adjudication in this country, the guilty plea, the plea bargaining process. And so the image that he used was, you can think of the due process model as the assembly line or the conveyor belt model, whereas the due process model was the obstacle course. Well, while to some degree at least, the Warren Court reflected some of the values of the due process model, the war on crime that replaced it was very much embraced the crime control model. And that became, again, the dominant philosophy. But the thing that, from my perspective, that's most interesting about this is that this way of viewing the world, of viewing the criminal justice system, was one that viewed these two goals, crime control and due process, as being, or put another way, crime control or protection of defendants, as being always in tension, as always being trade-offs. And what's really interesting that has allowed reform to move forward to some degree, I believe, is the way that the Innocence movement has changed that dichotomy, has changed that way of necessarily looking at crime control and justice as always being antithetical, as always being in tension with one another. Why do I say that? Well, look at what's happened. The Innocence cases, we now have these 351 stone-cold innocent people proved innocent by DNA. We have these 2,100 other people. We now have a group of cases where we know that the system got it wrong. So we can study them. We can look at them and say, what is it that's leading to these errors so that maybe we can improve the system? And when you look at the DNA cases in particular, what I'm showing you is the data from the DNA exoneration showing the contributing factors. We can see that eyewitness error among the DNA cases is the leading cause of wrongful convictions. False confessions. Remember, these are rapes and murders, the most heinous kinds of crimes, yet up to a quarter of the people wrongly convicted and exonerated by DNA confessed falsely to these heinous crimes. What's going on here? We also see bad forensic science in over half of the cases. What's happening here? And the point I want to make about this, though, is because we can identify these problems, we can study them. And we can figure out what is it that we're doing wrong with the way we collect eyewitness evidence? What is it that's wrong with our forensic sciences? And we can then propose solutions, which we are doing. And these tend to be, not always, but tend to be win-win solutions, not trade-off costs, not that dichotomy between crime control and innocence protection or justice protection. Because if you improve the way that police collect eyewitness evidence, you improve the diagnosticity of the identification procedure, which means you have better evidence for convicting and you have better evidence for protecting the innocent. If you improve forensic sciences, you get better. So the point of this is that this movement has created an opportunity for reform that we haven't seen before, in part because it proves the lie to the claim that we don't convict innocent people, and in part because it allows us to tell human stories of wrongful convictions and attach faces and names and life stories like the story of Jarrett Adams, my good friend, colleague, and former client. But in part also because it gives us an opportunity to find common ground. And that common ground is, let's improve the diagnosticity of the process so we're reducing the number of both false positives and false negatives. One of the ways we see this happening is that prosecutors around the country, in some places, this is from a report from the National Registry of Exonerations reporting on the exonerations they found in 2016, and what they report is that there are a growing number of prosecutors' offices even that are creating what they call conviction integrity units. Units within the prosecutor's office where their goal is to go back over old cases and examine them to see if they made mistakes and exonerate the people. And so that in 2016, there were a record 70 exonerations instigated by prosecutors themselves. That's the good news. The bad news is most places don't have these. And where they do have them, some are really good and some are really atrocious. And what I'm going to skip over this in the interest of time. What we're continuing to see is enormous pushback from prosecutors in many, many places. Kate Judson is going to talk more about problems with science and scientific evidence. This was given an impulse, it's a greater impetus in 2009 when the National Academy of Sciences issued its path-breaking report on forensic sciences, where they concluded essentially that aside from DNA evidence, none of the traditional forensic sciences have a scientific base and have demonstrated any real reliability. And so because of that again is another lesson we've learned from these cases. Well, if we want to improve the system, we need to improve the forensic sciences. And so one of the first things that the National Academy of Sciences recommended was the creation of a National Institute of Forensic Sciences, a national body to investigate forensic sciences, conduct the underlying research, establish protocols, create systems for licensing and accreditation, create standards, protocols, all these things that are that ought to be present in any real science that simply isn't there in forensic sciences. Congress was in no mood to create a National Institute of Forensic Sciences. So to the Justice Department's credit under President Obama, the Department of Justice created its own National Commission on Forensic Sciences and was starting to do really, really good work. Again, this is a reflection, I thought, on the opportunity, but we face challenges. I'm almost there. Jeff Sessions, immediately upon taking office, disbanded the National Commission on Forensic Sciences. And why? Because he said, I don't think we should suggest that those proven scientific principles that we've been using for decades are somehow uncertain and leaving prosecutors having to fend off challenges on the most basic issues in a trial. In other words, basically what he's saying, don't confuse us with the science. Don't confuse us with the facts. We'd rather let our prosecutors rely on whatever the hell they want to rely on, even if it's junk. And so that's the challenge to the reform movement moving forward that we face, one of them that we face right now. So the path is not easy, we're not there, but the opportunities are there if we can overcome obstacles like this. And with that, I'm going to stop and turn it over to our other panelists to get a little deeper into the weeds on some of these issues.
If you grab that, I've got a couple notes.
Sure. So next up we have Kate Judson.
Thanks. So I thank you, Keith, for setting that up. I think my talk will dovetail really well with my colleague who's gone before me and my colleague who's going to go after me. I want to talk a little bit today about challenges in the criminal justice system with respect to forensic science and the challenges that can arise when we try to make changes without really understanding the underlying science and the underlying factors that contribute to wrongful convictions and other problems within the criminal justice system. And so I'm going to talk about the role of expert witnesses and the role of the kind of dogma heresy paradigm in criminal justice and the difference between science and belief, and how those things fit together. So I myself find that the most useful way to get at those lofty scholarly issues is by quoting a bumper sticker to you. So that's what I'm going to do. So there's been an increased interest, as you have probably noticed in the last year, about addressing things that are scientific truths and standing up for them. So I recently saw a bumper sticker with a Neil deGrasse Tyson quote. You know the one, right? The good thing about science is that it's true, whether or not you believe in it. And that's really appealing to people. But it's true in the way that a lot of conventional wisdom is true, which means that it's true-ish, right? It's true adjacent. And that's because science is a system. It's created by people and people work within it. Yes, it has rules, and those rules exist to try to make it as objective as possible and try to reduce bias that we have, but they're certainly not infallible. It's a fallible system. So when facts are lacking, when we don't, let me just say one thing about that. I think it's probably a useful quote if you're trying to illustrate that climate change is real and we should do something about it, or that cavemen didn't ride dinosaurs. But when we get down to the most complicated issues that we have to address in all the scientific disciplines, but in forensic science and the criminal justice system in general, it's too complicated for that science versus belief dichotomy to be really stark, right? So when the facts aren't there, when we don't have the underlying science, when we don't have the facts that we need to make an objective determination, we start to fill in with our subjective beliefs. And that's a place where bias can really enter in the issue of criminal justice and in the issue of forensic science. That's really what happens in forensic science. So where you have less data, less objective data, we rely more heavily on these sort of dogmatic ideas. We rely more heavily on the opinion of the expert and the person that who the expert is, rather than the actual science and the principles underlying their opinion. And this problem, as I said, is really amplified where we have less objective data, and just changing the rules, right, doesn't make things more fair. And I want you to kind of imagine it as changing the rules isn't creating a system that's more just. It's taking the injustice and moving it around, right? It's moving the injustice around. And so I want to illustrate that with an example from my own work. I work primarily on what are called science-dependent prosecutions, and generally in the area of child abuse. And I'm going to explain what that means. Science-dependent means that every element of the crime is based on the expert's opinion. So the prosecutor is trying to prove every element of the crime using an expert's opinion. And that differs from some of the identification sciences like fingerprint analysis or DNA analysis. The difference is that those disciplines you can think of as science-reliant. They're using scientific principles to prove one element of the crime, one area, either identity, establishing that somebody was at a scene. That's what those kinds of prosecutions are trying to establish. But I'm going to use the example of shaken baby syndrome here. That's a science-dependent science-dependent prosecution. So I'm going to give you an example. Okay, right? We've already talked about how the science is used to prove all legal elements of the offense. And what that means is that in these cases, the cause and manner of death or injury is proven by the medical findings that the child has. So when a child, in these cases, generally we're talking about a collection of some pretty well-described symptoms, usually some combination of subdural hematoma, which is bleeding around the brain, retinal hemorrhage, which is bleeding in the back of the eye, and cerebral edema, which is brain swelling, or encephalopathy, which is brain dysfunction. And traditionally, when physicians saw those signs, they would make the diagnosis that the child had been abused, and the nature of that abuse was shaking or shaking with some kind of impact. The opinion of the expert also provided the mental state of the perpetrator, right? So they would say that the testimony would be that the degree of force used was so significant that it proved intent or recklessness or deliberate indifference to human life, whatever the standard was. So the medical findings themselves showed the mental state of the perpetrator. And then that the medical findings themselves established the identity of the perpetrator. The belief was that because death or collapse would be instantaneous, there could be no period of time between the infliction of these injuries and the manifestation of them, that it had to have been the last person alone with the child. And this is what a colleague of mine has called medically diagnosed murder, right? They're saying her writing suggests that that this is a physician making a diagnosis of a crime, right? And that's troubling, right? It's troubling for a few reasons. One reason is that we know that doctors make decisions that are wrong in all kinds of different ways. We know from scholarly study and sometimes from personal experience that the leading cause of malpractice lawsuits and complaints against physicians is actually misdiagnosis, right? So the most healthcare dollars that we put into mistakes are not, giving someone the wrong drug or performing a wrong site surgery, but actually making a misdiagnosis. So we know it's a significant problem. And we also know that in an area where there's a lot of subjectivity, then a lot of bias can enter. So I'll explain a little bit more what I mean about that, but I want to give you a little bit of the landscape historically, because it's particularly a mess in these shaken baby syndrome prosecutions. So when this syndrome was first proposed, and for many years thereafter, generally physicians made this diagnosis based on this collection of symptoms. They would say, we saw these findings, and that tells us that these things have occurred, that we can tell the cause and manner of death, of injury, the mental state of the perpetrator, and the identity of the perpetrator. And now I know that there are experts who are strong defenders of this paradigm who insist that they don't do that and that physicians haven't done that, but the transcripts in hundreds of cases bear that out, and the medical literature and the textbooks that were printed during this time really bear that out. Doctors saw these findings and they made a diagnosis of abuse, sometimes without regard for the other circumstances, right? And they said it couldn't possibly have been an accident because, again, of the force required, and that it had to have been the last person with the child. So people were convicted, sentenced to prison, some received capital sentences, death sentences because of this kind of evidence, right? But then, there started to be exceptions to these rules, and just like Keith was talking about, there was an evolution of the science in this and many other forensic issues where we started to see that there had been mistakes, that people had made errors, and that wrongful convictions had resulted. And so as that started to come out, physicians and lawyers and scientists started to recognize that there were exceptions, that no longer could this be used as an absolute. There were exceptions to this. There were other reasons a child might have these medical findings. They might have an accident that was innocent. They might have a disease. They might have other medical conditions that would cause them to have these findings. And so then, attempting to correct for those exceptions without fully understanding the landscape and the underlying science was particularly problematic, right? Because what happens is more bias comes into the system, and then the decisions about who is and is not a person who's abused a child, who is and is not a murderer or a child abuser, start to depend more on the folks in the system making the decisions, their beliefs about what a criminal looks like and what a good parent looks like. So as we start moving away from this absolutely flawed and problematic definition, we start moving towards this idea of, making this diagnosis and ultimately criminal responsibility decision based on what the person looks like and how you think that a good parent or caregiver ought to behave. And there's an analogy here, though it's not a perfect one, to the idea of mandatory minimum sentencing, right, or definite sentencing. The analogy is that if you have a sentence that is known, right, there aren't a lot of places for subjectivity and bias to enter that sentencing decision. Yes, there are places for subjectivity and bias and injustice to happen at all these other places down the road. And the mandatory minimum sentencing scheme is not fair and was never fair. But getting rid of it makes it unfair in a different way, right? And the decisions that happened before we had that kind of sentencing, they were unfair in a different way because they hinged on what in the opinion of the judge or the prosecutor or the attorneys involved, what a criminal looks like, what a bad person looks like. And so that's an example. I think it's not a perfect analogy, but it's a good example of not getting rid of injustice, right? But taking injustice and moving it around. And that's kind of what's happening here. So with this increasing reliance on expertise, it's now particularly tied to values, right? So it's particularly tied to whether an expert is a good person or a bad person based on their opinion. And then those who argue with the, sort of the standing forensic science paradigm are increasingly viewed as heretics. And that's another problem that arises when we, again, base reform of the system not on a good understanding of the underlying science, but instead on sort of a reaction to uncertainty entering the process. So science, right? So now we know, right? It's true-ish that it's true whether or not you believe in it. But the question starts to be then, what do you do if there's no firm data, right? So now if we know that some injuries we thought were always abusive aren't, it's hard to tell what the abusive injuries are. And that has implications in many, many areas, right? So I want to in the last couple minutes that I have, I want to give some examples of places in the criminal justice system as it relates, and in medicine where we have bias entering the system where there should be objectivity, right? So part of the reason for doing that is that there's often this pushback to the idea that physicians bring their biases to the clinic or to the hospital. And I think most of the folks sitting in this room know that that's true. The Institutes of Medicine and the National Academies of Science have shown that that people's race, gender, socioeconomic status, religion, and other factors affect truly everything about their care. everything from the diagnosis they receive, to the pain medication they receive, to the treatment they're offered, even things like how long they wait in the waiting room before seeing the physician, right? So I want to address that, and I want to just use the most recent and probably one of the more egregious examples of this nursing textbook. Have you guys seen this on social media? Yeah. So this nursing textbook that was published in 2014 that talked about, it was the idea here is how to be sensitive to diversity and culture in your. This is perhaps one of the few areas where you should maybe just listen to the patient when they tell you how they feel and how much pain medication that they need. But this was published in. Folks in the medical or legal system, I want to make clear that many people who many Americans have never actually come into contact, met, or been friends with, been close to, been family members with a person of Native American descent, right? And given that important fact, it's particularly troubling that in this discussion about pain medication, we have a bullet point here. They usually tolerate a high level of pain without requesting pain medication. Right. Yeah. Yikes. And then this idea right below it that the description, that you don't necessarily need to trust the description your patient gives you of their pain if they are Native American or Indigenous. Yikes. Right? So I just use this not because it relates specifically to child abuse, right? But it highlights this issue of bias, prejudice, subjectivity in the medical system, and I want to clarify how that can bleed over into child abuse. I'm going to use one other example here before I'm finished it's very short, of an issue of this arising in a shaken baby syndrome case. In a shaken baby syndrome case, there was a that's being litigated on post-conviction. There was a child abuse pediatrician whose job it is to be involved in cases where abuse is suspected, who represented to a court that the parent accused in this case was more likely to have abused a child because of the parent's status as a transgender person, simply because of that parent's status. And this was not something that was hidden in a note that this physician never expected someone to see. This was something that a physician wrote in a report that was given to the court and the attorneys, and also something that was said in court in the course of the hearing. So this is just one example of the places where, once you get rid of these objective guidelines, which are not helpful and often not true, you still run into the problem of subjectivity injecting more bias and injustice in the system. So I just want you to hold that kind of idea in your mind of, when we don't really understand what's created the problems, we're not getting rid of injustice, we're just moving it around. So thank you. We don't need to leave that up there, it's horrific. We can take it down.
All right, so up next we have Michelle Nethercott.
Thank you. If it's okay with everyone, I'm going to sit here because one of the really great things about today for me, among many others, is that I'm not teaching a class and I am not arguing in court. So I'm going to avoid PowerPoints and I'm going to avoid the podium if that's okay. What I'm going to try and talk about today is what I would term the challenge that science poses to a faith-based criminal adjudication process. And when I say criminal adjudication, I use that term because I'm not simply talking about the trial process, which is largely not present in criminal adjudication. Over 93% of cases in this country where convictions occur don't go to trial. So I'm talking about these preliminary decisions to charge, which often seal the fate of the accused. And that's why I'm using that term, criminal adjudication process. So, Keith, you've stolen a couple of my quotes, but there's two left that I have. So, and I'm just going to put this in the context of a timeline. Judge Learned Hand, very respected, well-known federal judge who made that now famous, infamous statement about how how great our criminal justice system is. But I'm going to give you two others. In 1935, Edmund Pearson in the New Yorker magazine said, "The vision of American criminal law as a ravening monster forever hounding innocent people into the electric chair is one which emotional persons like to chill their blood. It is a substitute for tales of ghosts and goblins." And finally, 2006, Justice Scalia, in a Supreme Court opinion, assured us that things were fine because there is an error rate of 0.027%, or put another way, as he pointed out, a success rate of 99.973% in the accuracy of criminal adjudications. Now, if you look at how he arrived at that, you realize that he needed, if not a refresher, maybe a basic course in statistics, because the way he got to that is really pretty crazy. So into this kind of framework of the main actors, the law enforcement officials and the judicial officials that run the criminal justice system, as Keith said, beginning in around the late 80s and carrying on through the next couple of decades, forensic DNA technology comes along, and it begins to generate really incontrovertible evidence that the criminal process was clearly not as perfect as these men had characterized it. And prosecutors were in a little bit of a bind when it came to DNA because, of course, they were the ones initially who were using this in the courtroom. So it was, although some, in some instances, did oppose DNA, there was a moment there where there was actually some consensus on how we could actually count someone as wrongfully convicted. Okay. So my question is, just what data or evidence supported these claims of infallibility? What was any of that based on? And I think really none is the answer. It was really just a reflection of this extraordinary faith in the ability of procedural safeguards that admittedly are somewhat unique to the U.S. criminal justice system, things like presumption of innocence, the need to prove guilt beyond a reasonable doubt, the adversary system itself, were sufficient to ensure that innocent people were never convicted. I think these kind of extraordinary claims also reveal a kind of institutional vanity that's still with us today, that I would say really arise from what I'm going to call a faith-based culture that continues to permeate much of law enforcement and judicial culture, which, never being known for being overly positive and optimistic, I agree with Keith that much of what has happened has provided a moment for reform that's really unparalleled. But it's also generated some backlash and a lot of pushback. I'm borrowing from an author by the name of Yuval Harari, who wrote a book called Sapiens, A Brief History of Humankind. It's not that brief, but anyway, what he points out is that the scientific revolution was notable historically for basically introducing this idea, one, that humans don't know everything, the things we think we know could be proven wrong with additional data or knowledge, and for suggesting there was no concept or theory that's beyond challenge. It really represented a change to the pre-existing knowledge traditions in that it placed great importance on the centrality of observation, data collection, the use of mathematical tools to connect data and observations into comprehensive theories. And finally, it used those theories to acquire new powers and to develop new technologies. Now, all these aspects of the scientific revolution posed enormous challenges to pre-modern knowledge traditions like Christianity and Islam and Confucianism, who essentially asserted, in many respects, that everything that was really important to know about the world had already been revealed by God in the scriptures. And while certain individuals could be ignorant about things, skeptics who were claiming that there were important things about the universe of which the entire tradition was ignorant were typically marginalized and frequently prosecuted. So my point is that contemporary science, with all its flaws and all the problems that arise because of the cultural context in which it exists, is a knowledge tradition that admits collective ignorance of the most important questions. And so, for example, Darwin never claimed that he had once and for all understood the basic mechanisms of life. And even today, physicists debate or try and figure out how to reconcile quantum physics with the theory of general relativity. I think just as those emerging concepts that were associated with the scientific revolution posed a great threat to the existing socio-political order centuries ago, what we're seeing today is scientific evidence regarding basic evidentiary building blocks of the criminal justice system, things like eyewitness identification, confession evidence, forensic comparison evidence. They come to pose a threat to our faith in our current criminal adjudication process. And the threat has been met with a lot of hostility on the part of courts and law enforcement officials to incorporating knowledge derived from both the soft sciences, social sciences, and to some degree even the hard sciences. And ironically, I think, to a really reflexive defensiveness of what I would say are many completely unscientific, or at least at this point, they have no science to support them as science. Forensic science enterprises such as fingerprint comparison, bullet lead analysis, microscopic comparison, bite mark evidence, and I could go on with this list. And what we saw in those disciplines were experts, forensic experts coming in, testifying in courts routinely about zero error rates. They never made mistakes. And they could identify the source of a latent impression of some kind to an individual to the exclusion of every other individual on Earth. And the truth is, there wasn't one scintilla of reliable data that supported any of these claims. And so I guess the question is today, well, so how is this clash to be resolved? I think the science and the legal system have, to some extent, always existed in a state of conflict. Our legal system is trying to determine, quote, the truth through an adversarial process, the ultimate purpose of which is to obtain a final, authoritative, and socially acceptable resolution of disputes. Science, on the other hand, is primarily concerned with understanding and describing the world as it is, not as it should be, but as it is, and doing it through empiricism and the collection of data. And in addition to this underlying tension between descriptive and proscriptive approaches, scientific evidence has sorely tested the capacity of judges and lawyers to understand and evaluate scientific evidence in a meaningful way. So over the last few decades, we've seen in the U.S. and not just in the U.S., in other countries as well, hundreds of exonerations involving convictions obtained based on forensic science individualization techniques that purported to establish the identity of a perpetrator with complete uncertainty, complete certainty, only to be shown later on to be completely wrong. And as Keith said, in 2009, National Academy of Science issued a report on the state of forensic science, which was quite damning, and I won't repeat the quote. And this damning systemic assessment from the most prestigious scientific body in the U.S. led to the creation of various committees and work groups within the forensic science community and the larger scientific community. And ultimately, subsequent to the National Academy of Science report, under the Obama administration, there was a report called the PCAST report from the President's Council of Advisors in Science and Technology. It addressed these so-called pattern matching forensic disciplines like bite mark analysis, fingerprint, shoe tread analysis, and even complex DNA mixture analysis, which is a real big problem. And essentially the report said, well, in addition to the fact that there's there needs to be a whole lot of work done to show scientific validity and reliability with these things. And until you do that, you might want to think a little differently about how you're using this in the courtroom. Well, here was the response from law enforcement. Then Attorney General Loretta Lynch said, quote, "Forensic science helps juries identify the guilty and clear the innocent, and the department believes the current legal standards regarding the admissibility of forensic evidence are based on sound science and sound reasoning. While we appreciate the contribution to the field of scientific inquiry, the department will not be adopting the recommendations related to the admissibility of forensic evidence." The National District Attorneys Association was less diplomatic and frankly somewhat more hysterical. And it said, "It's unfortunate members of PCAST, none of whom are forensic practitioners who have been trained or tested for competence in the forensic disciplines, ignored vast bodies of research authored by true subject matters experts. Notwithstanding their lack of qualifications, they've taken it upon themselves to usurp the constitutional role of the courts, decades of legal precedent, and insert itself as the final arbiter of reliability. The determination of whether scientific evidence is reliable and admissible must remain with the judiciary. National District Attorneys Association will continue to serve the citizens of this great nation by striving to improve our constitutional system of justice and to defend it against those who would seek to undermine the role of courts, prosecutors, defense attorneys, and jurors." And that kind of response was echoed by many of the forensic science associations. And I think it's really, to me, it's the language of calling out heretics. So our current Attorney General has decided that the best approach to the challenge that science presents to unreliable forensic science evidence is just to end the debate entirely and reject the science, which is not surprising since that's been the approach in a number of other contexts as well. So in conclusion, I'm not trying to be simple-minded about or too glowing about what science is. It's a human enterprise. It has its fair share of hubris and delusionary thinking. But I think at bottom it's a knowledge tradition that is at its core very humble about what it knows. It acknowledges uncertainty and the inevitability of human bias and tries to control for it. It embraces a probabilistic description of the world. The criminal adjudication process, on the other hand, not so much. And I think that I'm not that optimistic that courts and law enforcement officials will, by themselves, make the kind of changes that I think need to be made without a public consciousness that forces it. I think the public, who these institutions serve, are going to really require that judicial and law enforcement officials approach their truth-seeking function with much greater humility and self-awareness and less reflexive defensiveness. I don't think we need high priests of justice. We need a commitment to improving the attainment of justice, and I hope that the Innocence movement can be part of that change. Thank you.
All right, thank you very much for that, Michelle. So next, I want to introduce our final speaker for this panel, Jarrett Adams. I'm just going to pull up his PowerPoint. Which one's yours? Great. All right, Jarrett, the floor is yours.
All right, thank you.
Yeah.
Hello, everyone. All right, thank you for having me a part of this panel. I really appreciate it. And that's a nice headshot you got in there, so I'm very happy for that. I can send that to Mom. She'll like that one. So I want to, I'm increasingly doing more and more speaking events. And so what I like to do and what I found that is effective is when I tell people about what happened, that's one thing. But when I'm able to show you, it just takes on a whole different meaning. So I'm going to be showing you guys a lot of pictures, and then I'll get to some relevant stuff, some walkaway points that I would like to hammer home. So it's kind of unique too. This is the first time I'm doing a slideshow, and Keith is in the slideshow, and he's here. So this is very unique.
Probably
So
looking a whole lot younger.
yeah, well, you still got it, Keith. You really do. So this is me. I'm 17 years old. This is 1998, and I was just graduating high school. And I made the fateful decision to go to a party with two of my friends. I told my parents that we were going, I was spending the night over a friend's house. One friend said he was spending the night over my house. Just the classic old, cover that all friends did. So I'm born and raised in Chicago. The state of Wisconsin borders Illinois. So you can get to Wisconsin in about an hour and be in Wisconsin. And so that's where we were going. We're going to a party in Wisconsin. I wanted to spend the night over one of my friends' house. So we go to this party. It's the typical college party atmosphere. There's drinking, there's smoking, there's casual sex. It's all there. About 2 weeks after going to this party, I come home and there's a card in my door. And the card says it's from robbery homicide and they want to talk to me. So I had never been in any trouble before, never arrested or anything like that. So I immediately call a number because I just know they got the wrong guy, right? So I called and I'm talking to this police detective and he's like, look, we know it's not you. We just want to clear your name. You've never been arrested. We don't have a picture of you on file. Can you come on down and take a picture and talk to us so we can clear you from this investigation? So I told him, I said, yeah, I'm on my way down now. He said, no, wait, why don't you come on Thursday? This was like a Tuesday or something like that. And he's like, why don't you come on Thursday when I'm in the office? So I'm like, okay, fine. Should I bring my parents? How old are you? He asked me. I was like, I'm 17. He said, when's your birthday? I said, November. So now this is at the end of the summertime around September. He says, oh, no, you're fine. Just come on down here, take the picture, ask a couple questions, we'll get you out of here. So I go down on that Thursday. When I go down on that Thursday, there's an investigator from Wisconsin that is in the room. And they're not asking me about a robbery. They're asking me about a rape. And it was simply not true. So after I get through explaining to them that we raped no one, we was at this party, we met a bunch of people there, they tell me I put myself at the scene of the crime and I'm going to be charged along with my two friends with the rape. The accusations were that me and my two friends snuck up a flight of stairs, we walked our way into a girl's room, we cut off the light, and we intimidated her so much by our presence that was enough to meet the element of first-degree sexual assault. That's what the allegation was. Now, I cannot gloss over this without mentioning we were all black and my accuser was white. So I'm going to sprinkle in some science, but I'm going to have a whole lot of realness in my slideshow, okay? So now, very quickly, from that point of this, 17 years old, I believe this is June when I graduated, this is how I next look. And I believe it was in September. I believe that's when I was arrested in September. And I am getting ready to turn 18 in this picture. This is a small uniform, but you can see it's draping over me. I didn't have this NFL physique that I currently have now, so I was simply just a kid. And there was a lot of craziness that happened with throughout the entire case as far as how it was tried. I was appointed a panelist attorney along with one of my co-defendants. My other co-defendant, his family had a little money, and they put up their house and some other assets to be able to secure a very good attorney in Wisconsin. Now, although all we were dealing with was an accusation in this case, this wasn't just as simple as an accusation. This is an accusation that history has shown black men in America never made it to courthouses, were drugged out of police stations, never made it in front of a jury. And so this was different. This wasn't just an accusation. So his parents were able to muster up money and they hired an attorney. We initially all go to a first trial. When we go to this first trial, the testimony changed again from our accuser. And I believe that she was starting to feel guilt. So the testimony and the narrative changed. It changed so much so that before it went to the jury, the prosecutor stood up and he said, look, we want to amend the charges down to 3rd and 4th degree. Because based on the testimony, there was no proof of anything, but they still didn't want to do what was right because they have the discretion, the sole discretion, to try a case or dismiss a case. And in this rural town where the only things of color were the lawyer's suits, judge's robe, and the defendants, we weren't getting justice. And it was just as simple as that. It was a very small town, Jefferson County, Wisconsin. So trees fall in the wilderness without anyone hearing it all the time in that part of town. And that's exactly what happened with us. At the end of this first trial, it ended in a hung jury. Well, not a hung jury. It ended in a mistrial because the court declared a mistrial because the paid attorney, Boyle, asked that the case be dismissed because the prosecutor wanted to drop the charges down and basically just get the jury to convict on anything. So meaning that they don't want to convict on the evidence, but if they convict just to find a way out. Juries sometimes do that. There are a lot of strange decisions that come out of juries' rooms, but they don't really have to do with the evidence that is displayed at trial. So there's a mistrial declared. We go back to trial again. We're ordered by the court not to talk to each other. So we didn't have communication, and I was still in custody. Like, my mother couldn't afford the bond to get me out. So I was in there the entire time. And so we go to trial again about 3 or 4 months later. When we go to trial, there's just me and Dimitri. The paid attorney isn't there. The paid attorney files a motion, and the motion is basically saying that this is double jeopardy. They shouldn't be retried again, and basically give a second kick at the cat is a term that a lot of legal people use in the legal world. Well, the prosecutor, basically decided to sever our case. The attorneys did not tell us anything and give us the option to join in this appellate argument that was being made. And I'm telling this part of the story because it's very significant and it teaches us a couple different things. First of all, the criminal justice system is about race and it's about wealth. And we were on the wrong side of both of those things, right? So when we go to trial, the paid attorney isn't there, my other co-defendant isn't there, and they call us into a room, the attorneys. My mother's in here crying her eyes out. And this attorney is telling us how he thinks it's a good idea for us just to go ahead and go to trial, get it over with. He was telling us how confident he was from what happened in the first trial, that we wouldn't be found guilty. There's a reason why the prosecutor stood up and wanted to amend the charges. It just simply isn't there. These boys are innocent. So I'm looking at my mother and I'm listening to this fool, and I don't want to do it, right? But I'm looking at my mother. And at the end of the day, it was my fault. We didn't rape anyone, but I decided to go get in that car and go to a party that I did not have to go to. So I took full responsibility for that. And I ended up listening to him, and we go to trial. We go to trial. They present absolutely no defense at all. No defense. Didn't even impeach the accuser with the prior testimony and different statements and stuff like that. Day and a half, we're found guilty. We're found guilty, day and a half. A couple of months later, we're sentenced to serve my co-defendant. We both had 20 years, but I got up and I stood up in court and I said, look, I'm going to apologize, but I'm not apologizing for a rape I didn't commit. The judge told me I wasn't remorseful. She gave me an additional 8 years in prison. This 8 years was very significant. It changed the course of my entire prison experience because now I'm in maximum/super maximum prison with everyone there who has like 25 years and above. So it changes the atmosphere significantly. So now while we're in prison, my co-defendant, the one with the paid attorney who filed the motions, he's been denied his appeal. So he has to go back in front of trial. So when he's going back to trial, I had a little bit of time to sit and to think about all of the things and what we were actually accused of. Like, I didn't know at the time. I just knew how to say, look, we didn't do it. It wasn't true. But I didn't know the significance of what we were being accused of and the significance of the people we were around playing video games with. Like, we were the only 3 black kids on that campus. It wasn't hard to find a timeline of where we were through other witnesses. So with that idea, I wrote Boyle, who was my friend's attorney, and I said, look, I was playing video games with a guy. And when this girl came in the room to invite all of us up, I stayed down initially and my friends went up. And I played video games with this guy named Sean DeMaine. And more importantly, when I went up to go get my friends, afterwards, we all came down back in this general smoking area and we saw the guy we were playing video games with at the beginning. So you tell me how we sneak up a flight of stairs, gang rape someone, and flee a building, right? So I told Boyle he needs to go and go talk to this guy. So he goes to go talk to the witness. He talks to the witness. The witness is like, look, I told you guys everything I needed to know. I even wrote you a statement. Like, what else do I have to say? So the investigator's like, no, we never talked to you, and we certainly don't have a statement from you at all. It was at this point that the investigation started, the wheels started, and all of a sudden, lo and behold, the police officer says, you know what? We made a mistake and forgot to turn over this statement, right? And it was the statement from this witness, Sean DeMaine. Now, I'll let you guys draw your own conclusion if the only alibi witness and only supporting evidence of our alibi just was mistakenly left out. So I'll let you guys draw your own conclusion on that. And so at this point, the prosecutor decides to dismiss all the charges against Rovan. Now, naturally, you would think that that would mean for the very least for us, we get a new hearing, right? Well, no, that's not what happened. The prosecutor decided that because our attorneys decided on a no defense strategy and they weren't calling any witnesses, therefore it didn't matter because we weren't putting any witnesses on, so we wouldn't have put the statement on, which absolutely doesn't make any sense by the wrinkles and creases in your face and your forehead. Right. It doesn't make any sense at all. Forget the fact about justice, about the fact that this proves our innocence. Didn't care anything about that. They had the nerve to tell me in the rest of our defense about strategy and how they don't look at strategy and it's up to the attorney. So now I'm in prison, and the thing about prison is this: one Christmas will turn into 4 and 5 before you know it, and that's exactly what happened. And I got into a place where I wasn't responding to letters, I wasn't taking visits. And you just don't do that to black women from the South. So my mother and aunt called the warden so much that they made me like go on a visit one time. But I become so despondent. I didn't want to deal with it anymore. It was my therapeutic way to just ignore the situation. You got to understand that I'm 18, turning 19, 20. All of my friends are going off to college. I'm getting pictures and letters from them, and they're telling me about their experiences with college, first cars, first credit cards, maxing out their first credit cards. All the things that you go through when you matriculate through being an adolescent. I missed all of that. So at one point, I was encouraged by a cellmate to stop playing chess and working out and acting as if I'm on a college campus. And if I was really innocent, then I would act like that. And I would start to go to the law library and start to learn and understand. And that's what I did. And my letters went from, look, I'm innocent, to look, I am innocent. And the Supreme Court case in Strickland versus Washington supports that. I had ineffective assistance of counsel. This is a two-prong test. The first prong is that your lawyer was ineffective. The second is that his ineffectiveness affected the outcome of your case. And the thing that my cellmate pointed out to me was like, look, people can meet the first one all the time. The second one, no one ever really meets. And the second prong was already proven in my case. If the same statement and the same evidence was strong enough to dismiss the charges against my co-defendant, how on earth could it not be strong enough to at the very least give me a new trial? So essentially, I had to figure out how to get help. So as my writing and articulating became better and I started to grasp a little bit of the knowledge that I knew of the law, I started to write better. And one of the people that I kept writing was the Wisconsin Innocence Project and Keith Findley, and at the time, John Prey. So the thing about the Innocence Project is this. I'm not the only one who's writing them. And their resources are very limited. So I started to write, and I started to do expansive writing like it was a brief coming through there. So I made it very understandable so that it was like, look, you won't have to spend as much work on this, and more importantly, my deadline for a habeas was running. And I think when you guys came and saw me, it was like 9 days or 13 days left.
About a week. Yeah.
It was about a week left that we had, and I would have been in the same predicament that my co-defendant who was incarcerated with me is in right now, and I'll touch on that in a second. So Keith, they come and see me, and they asked me a crazy question. They asked me, did I want them to represent me? I'm like, of course I want you guys to represent me. So they filed the case. They argued it all the way up to the Seventh Circuit Court of Appeals. The Seventh Circuit Court of Appeals is a federal court. It was a habeas petition, and they unanimously agreed that my attorney was ineffective, and that statement should have made it in. There's no way. And with that, my conviction was reversed. The prosecutor, months later, would file a motion doing the very thing that he should have done almost 10 years later. And he filed the motion dismissing the charges against me. I was released in February of 2007. But you have to understand that as elated as I was, the reality is that it was a decade gone. So I'm incarcerated in 1998. I don't get out until February of 2007. So that's gone. I don't have a record, but when someone looks at me and asks me about my job experience, they want to know what island I was vacationing on for 10 years, right? And that's hard to explain. And then there was just a lot of other stuff that I had to deal with as well. I didn't see one of these when I got out. cell phones are gone. I mean, pay phones are gone. Back then, if you had a cell phone, it was about as long as your arm, and the antenna was as long as your leg. And you used to have to screw this thing on, and that was the reality of what I was faced to reintegrate back into society with. And to pause to briefly explain about the deadline, my co-defendant was trying to reach out to the Innocence Project at the same time as well. But because his attorney, his appellate attorney, filed his appeal, I believe, weeks earlier than I did, his deadline was earlier than mine was. So he missed the deadline to file. But Keith Findley and the Innocence Project represented him in another petition to the court that was in the interest of justice, and the court ended up, reversing his conviction. Well, the prosecutors argued not about guilt or innocence, but they argued that procedurally, he's barred because of him missing the deadline. And the Supreme Court of Wisconsin reinstated his conviction, but the judge, thankfully, the Innocence Project was able to argue so that my co-defendant was able to basically get what was essentially like he was just a commuted sentence, I believe it was, where he would be out and now he's like not on parole or anything like that. But all of this came about like 3 or 4 months after I was released. But he has been in the battle to get this off of his record ever since. And it's just absolutely another sign of the flaws of the criminal justice system. Like, they don't care about justice. They care about finality, right? Because then that allows them to duck liability in all sorts of ways. Because you can't explain to me how you have 3 cases, 3 different outcomes, and it's okay for him to have this on his record. It's just absolutely, it makes no sense at all. So when I come home, I realize very quickly that I could sit and play victim, and I'll be a victim right now today if I decided to do so. And more importantly, look, the value my mother put in me and my aunts put in me, I owed them women, and I couldn't come home and just sit on my butt and not do anything. So I would like to tell you and stick out my chest like a 10-foot peacock and let you know that I knew I was going to be an attorney, and this was easy and all that. It wasn't easy at all. I had to accept that I needed to go to therapy. Like, I had to do that. It's another thing that I argue is a component that is missing from criminal justice. It's the therapy. Now, get this, right? We'll introduce science when it's time to prove your guilt, but we don't want to hear anything about science when it's time to help you reintegrate back into society. Now, that is absolutely asinine. And another thing is, it's funny because we can advance in science with things like DNA, but we don't advance in criminal justice with things like justice. And it's just the reality, and that's exactly what it is. But in order to get to the point to where I am today, I had to accept that I needed to sit down and I needed to talk and I needed to let it out. I had to find a way to turn my anger into fuel to drive me to where I am today. So I initially I had a struggle when I got home. I couldn't find employment, and it wasn't because I had a record. Well, when I got out, they started this new component to looking at a person that applied for a job, and it was called a credit report. And my last known address was a maximum security facility in Green Bay, Wisconsin. So people were, all of a sudden, I remember interviewing with this one lady. Now, look, I didn't know this lady, but I mean, I could have babysat her kids after this interview, right? That's how well this interview went. And she gave me all of where I would be working at. And this is Comcast cable and all this type of stuff. So she's like, look, you're going to work in here. You did well on the test. All of this. Mysteriously, after a third-party agency did a credit report, all of a sudden they found a better candidate, right? So that's what I had to deal with getting out. I didn't have any insurance. I remember injuring my foot. I walked around for about a year with a fractured foot because I didn't have any health insurance. I was 26, turning 27 years old. I'm laying on my mother's couch with like a gap in my life. I didn't even know how to do an email or anything like that. In fact, I enrolled in a program that helped formerly incarcerated people like learn WordPerfect and all of that type of stuff, the stuff that was coming out. And I remember being told that I couldn't partake in the program anymore because their grant was tied to the heads of convicted felons that they helped with this. I wasn't a convicted felon, so I couldn't get the help that I needed. So eventually, I was able to work my way all the way to school. I started with my associate's degree, bachelor's degree, and then I graduated from Loyola Law School. And so the picture is a bit blurry And the reason is because my mother was screaming at the top of her lungs, "That's my baby," as she was taking this picture. So it was a moment that was fulfilling, but I still felt so unfulfilled. Like I must be honest, I wanted my leg back. I didn't know how I was gonna get it, but I knew just simply having a law degree wasn't it. That wasn't it. So I needed to find a way to figure it out. So I started to execute a plan like a grandmaster in chess. I was able to work and clerk in the same circuit that overturned my conviction. And this is the Seventh Circuit Court of Appeals. I developed a real good relationship with a Seventh Circuit judge named Judge Ann Claire Williams, and she basically mentored me. Judge Williams is retiring now, but she has affected the lives of so many people, and through that I grew. Like I grew to become and understand what it was that I believe was my mission in life. The Seventh Circuit, I'm telling you, I should go play 777 because the Seventh Circuit overturned my conviction. I clerked in the Seventh Circuit, and I met my wife in the Seventh Circuit. So, and I know what you're thinking. I hope the kids do come out looking like her. She's a very beautiful lady, and she's also an attorney as well. So, after the clerkship, after getting married, I went and I took and I passed the New York bar, and I wanted to work at the Innocence Project, so they gave me the great opportunity of being able to do that. I knew that ultimately I would be doing a lot more. Didn't realize, I didn't realize everything would just materialize so fast, right? So you're talking about within 10 years. It's the tale of 2 decades. So they took a decade from me, and in less than a decade, I'm walking through getting sworn, right? And this is me walking out of the New York bar. Now, initially I said I wanted to take the New York bar, the Illinois bar, and California bar, but after the New York bar, I didn't want a candy bar. I was like done, and I learned the art of being able to pro hockey into different states, and so that's what I'll be doing from now on. So now this is a goosebump moment. It really is, because when you're at the Innocence Project, you are assigned different states. And one of my mentors at the Innocence Project was Bryce Benjet. And Bryce, he really took me under his wing at the Innocence Project. And one of his cases was in the very state of Wisconsin. So he brought me on to this case. And this man is Richard Baranek. This is a client of jointly the Innocence Project and the Wisconsin Innocence Project. And he was in prison for much of some of the science that was spoke about today. It was junk science. It was a hair analysis that was done by an FBI agent. And when I tell you hair analysis, that sounds too technical for exactly what the man did. He plucked the hair from our client, looked at the hair recovered from the crime scene, and said, "Yeah, I've been studying hairs for over this amount of years. I save cats out of trees, walk old ladies across the street." So you're telling that in front of a jury. Come on now. Now, who do you think is the jury is going to believe? Despite our client having several witnesses that placed him in another state working at the time, they still believe this, and he was found guilty. So years later, the hair was found. DNA testing definitively proved, guess what? Wasn't his hair. It wasn't him at all. The conviction was reversed, and that was a great moment. But the greatest moment was this next picture. I was co-counsel with this handsome guy, Keith Findley, and it was a heck of an experience. So I got 2 minutes left, but before I go, I want to take and have you walk away with a couple points. I want you to think about the busiest car wash you've ever seen in your life, right? And I want you to think about how sometimes when cars go through, because they go through so much, and the car wash is man-made, sometimes you miss a bumper, you miss a fender, whatever it may be, right? Well, usually when you go to the attendant gives you a voucher or he tells you go right through, it's fixed, right? Now I want you to think about the criminal justice system. People go through there on average just like cars do. But when there's a problem, an identifiable problem like a wrongful conviction, you don't get to go to the attendant and he gives you that voucher like that. You're fighting for 10 years almost to prove your innocence. So you have to look at that and you have to ask, do we care about cars more than we do people? I'll use another car analogy. Imagine if more than half the cars that were made off a production line were back on that production line within 2 to 3 years. We would have a national debate. Congress would shut that car company down. Well, why is it that when people re-enter back into society and they come back so often, why haven't we shut the criminal justice system down? And here's the reason why. So I want you guys to look at these last 2 slides. So there's a prison boom that took place while I was like my entire life. I was born in 1980. While I was in prison, it went up. Here's the correlation to that. This old company right here, it's a prison company, right? It's one of many. Now look at their stock. You see that rise? And it's continuing to rise, right? That's real. This thing is about money, okay? There are people getting paid. In society, if we are able to show that things are problems and they exist and they still exist, they're not a problem from everyone. So I'm gonna close with this last story. This is a story from my grandfather. Now you guys know what this is, right? Now, he used to say, no one really gives a crap until that crap is on the bottom of your shoe. So I'm gonna take that a bit further. You could walk past some crap on the sidewalk and you probably be like, look, someone needs to clean that up. But if you step in it, oh my God, you're taking your shoe off, you're wiping it off, you are fully invested in the crap. You're knocking on doors, you're talking to people, you're seeing people with other dogs who didn't even do that crap, and you're telling them, you just need to pick up after your dog, right? Well, that's what we need. We need people who care about the crap before they put their foot in it, because we're not gonna fix this thing by one side. Our criminal justice system pits sides against one another, and I don't care if it's a spoon clapping contest. When you go up against someone, you're trying to win. You never hear the prosecutor say, look, vote for me, because I made a mistake one time and I wrongfully convicted someone and I do the right thing. They always say, vote for me, because I'm gonna lock them up, throw away the key, and the jail and the key. Thank you all.
Let's thank Jarrett and our panelists again, and it's really meaningful work.
So I'm going to just give a little bit of announcement. We're running a little bit behind schedule. This was scheduled to be done at noon. It's 12:15 now. I know folks have questions, so I want to allow for questions. So we're going to end this at 12:30. However, the food is already outside, and the lunch session is going to be pretty freewheeling. So if you don't have a question, you want to just start and grab food, you're welcome to do that. Folks who have questions, I'll be passing the mic around. And again, thank our panel for their wonderful presentations. Yeah.
How you doing? Since ain't nobody gonna ask questions, I guess I'll do it. The gentleman on the end, I'm from Illinois, Lake County, Illinois.
Oh, Lord.
My daughter live in Milwaukee, Wisconsin. It's one of my kids, so the criminal justice system, like he talking about, it's legit. Remember that they closed the projects in Chicago, and they get them vouchers up north, and everybody that went up north with them vouchers went to jail? The system designed for our failure. It ain't designed for our success. And it wasn't designed for us anyway. Now, in his case, and I can name a lot more cases because I spoke to the young lady on the panel yesterday. They got Benny Starks, they got Juan Revere, and they got Alton Logan. I was doing a documentary about racism in the justice system, you know what I'm saying? And I'm a whistleblower. I've been locked up in Illinois and Maryland just to prove a point. State's attorneys work with the judges. It's like playing cards with three friends and a stranger. Am I right or wrong? If you walk in the courtroom and you black or you poor and you ain't got a tie in the community, it's like playing cards with three friends and a stranger, and you got to beat all three of them. Your public defender wants you to plea out. He don't want to take you to trial. They rather win your cases on appeal. You feel me? That's why they got that ineffectiveness of counselness that works. You feel me? So my question is, if we already know the system is broken, we got enough people that's been in the system that can prove it's broke, why can't we start putting the system on trial, holding the system accountable? You know what I'm saying? Start suing the system, because like you said, money count itself, right? So if you go to them judges and them lawyers and them politicians, find out who's surety bonds. You know what a surety bond is? Find out who surety's bond is tied to them corporations and they 401ks. That's what you call racketeering, right? You feel me? That's slavery reinvented, and you getting paid to enslave us. You feel me? I'm telling you what I know because I've experienced it. I'm still surviving. I'm going through my 10 year of the desert now because of what I did 10 years ago, exposing this. You know what I'm saying? So I'm looking for my 10 years on the rise like my man.
So I'll comment on that, but
If you can use the mic, Jarrett, over there. Thank you.
My comment on it is if you just look at the criminal justice system itself and look who it disproportionately affects, it affects the people who wasn't at the table when it was created. So if you look at some of the issues, like for example for bail, you know, when the people created, you know, the criminal justice system, and they're like, all right, well, if someone's accused of a crime, well, they just bond out, right? You know, yeah, just bond out. You know, you just post a bond, as simple as that. That's because oftentimes people who have don't understand like the experiences of people who don't have, right? So the bond system has been punishing and hurting a lot of people as a result of them simply being poor and not able to bond out. And then you look at the criminal justice system as a whole. You have to understand that someone is getting paid for flip-flops, shower shoes, phone calls. One of the things that our favorite Jeffrey Sessions did was he started to talk about how it's not safe. It's not safe. We need to lock them up. We need to lock them up. We got to get tough on crime. And so what happened as a result of that is the stock in these corporations and private corporations and these phone companies and stuff like that, it went through the roof. You know, it went through the roof. And then, you know, one of the second things he did when he got in there, I think it was less than 3 months, he took a cap off of how much these phone companies can charge inmates for calling home. Now, I don't know about you all, but that didn't make me feel any safe out here, you know, by him doing that. So you have to ask yourself, okay, so why did he do it? Because it's a business component, right? I believe you when you say follow the money. How many of those prison corporations, businesses, and all that type of stuff, how many of those people donated to the Trump campaign? So could you say that's a way of them making sure that they get paid back? Because if you have private prisons that were closed and being closed and now they're being reopened, and we're talking about immigration, as an investigator with the Federal Public Defender's Office, I dealt with a lot of immigration. And let me tell you about immigration. No one goes right out of the country and be deported. You're housed. You're housed at different places. And so what happens when you're housed, right? They make money off you. There's money that is being made. So I'm not crazy at all. And I know for a fact that that's what it's about. It's about the money aspect. And it's about us being able to diversify the system itself. Like, I believe in marches and things like that, but I believe to truly change, you got to be a part of what it is that you're trying to change. And so I think that we need to hold people accountable. When people run in office and they say they're going to do this, they're going to do that, if they don't do it, get them out immediately. No second chances. And so we have to execute our powers to vote and take back what is affecting our community. When people reintegrate back into society, especially in Chicago, they only go back to 2 neighborhoods. That's the west side and the south side, right? So those neighborhoods are the ones that you don't be shocked, but their school systems are poor. There are no jobs. There are liquor stores on every corner. There are churches next to the liquor stores on every, like, it's go to every community like that. So we do have a lot of work.
Other folks?
Thank you all for your presentations and testimonies. So my question is, I work with justice-involved people in my own academic work, and what I've noticed is most of them, even going to prison, going to halfway back programs, are not staying in for long amounts of time. They're not the kind of people where the Innocence Project could probably come in, because there is no forensic evidence. There is no way of proving their innocence. It's low-level stuff that's cycling people into. So the question is, what's the role of the Innocence Project in expanding to lower-level, still people that are serving time, but lower-level, less serious offenses? And I'll just give you one anecdote. The prisoners that I worked with in the Bo Robinson facility, which was on the front page of the New York Times for its injustices, used to tell me, oh yeah, they fully expect that even though this is a halfway back program, that we will be back through, and the correctional guards will wave and say, see you when you get back. So while they are telling us, be responsible for our choices, they're also telling us that we're going to be back through. The expectation not just of profit, but of cycling and of churning and they know that people are returning to communities that don't have jobs, that don't have high quality educations, and they expect the return. They see themselves as being not just a stopping ground, but as a semi-permanent home. So how do we deal with that? People who on a parole revocation are coming back through and being told, see you when you get back.
That's a really important point and a very serious problem that we're dealing with, because you're right. The innocence movement up to this point has been devoted almost entirely to big crimes, long sentences, and it's done that. It's gone that route for several reasons. I mean, those tend to be the kinds of cases with forensic evidence, with the DNA. But I wanted to be clear about one thing. The Innocence Project in New York does only DNA cases, but most of the other projects around the country handle all kinds of evidence. So theoretically, they could handle these little cases, smaller cases with other kinds of evidence. The problem is, of course, one of resources. Most projects, I don't know about the one at University of Baltimore, but most projects, as a matter of triage, say as a matter of policy, they won't even consider somebody unless they've got 7 or 10 years left to serve, simply because they can't get to them all, so they're going to handle the ones that are the most pressing, the most in need. So its resources is a big part of it. The other problem is, of course, because the sentences are so short and because nobody has the resources to look into them, I mean, comparatively short, and the research literature is starting to recognize that probably the vast majority of innocent people, of wrongly convicted people, are in misdemeanors. And they're there by virtue of guilty pleas, where people plead guilty to get the process over with, right? But the reality is we know almost nothing about them. Right? We don't have the data. We don't have. It's a very difficult thing to study. So the good news is that we're recognizing that, and scholars are starting to look into that. The Innocence Project in New York just has sort of coordinated a nationwide guilty plea project. So we need more resources, but we need more data. And we need more research to look into these so we can figure out what it is we can do about this. I wish I had a better answer for you, but just raising the concern is really important because it is one that's been overlooked and that we are just now starting to deal with.
I would add to that, you asked about the role of innocence efforts in addressing that problem. And the role has been, in addition to what Keith said, using science, using hard sciences and social sciences and other principles to determine which people have been wrongfully convicted informs all these other decisions, right? So the role of DNA analysis in innocence work and the role of other kinds of analysis in innocence work has taught us that, for example, we used to think that nobody who wasn't guilty pled guilty, right? And so now we know unequivocally that that is false. And that really helps move the ball forward in terms of every single crime, whether there's forensic evidence or not, whether there's eyewitness evidence or not, whether it's a misdemeanor or a felony, recognizing from the data and the research that's been done that these are the factors that contribute to wrongful convictions. If they're present here, we know that we need to start looking for wrongful convictions. So that's kind of even though we don't focus on misdemeanors and even though we don't focus on, 3rd and 4th degree felonies, the work that we've done in these other cases really has informed and moved forward the movement to get justice for people who've been accused of these other kinds of crimes.
As I think about it, let me just add one other thought also. And this is another example, I think, of an area where sort of the two trends, the two factors that I identified at the outset, I think are starting to work in tandem, and that is the response to mass incarceration and disparate rates of incarceration that's starting to get some attention, is complemented by the innocence work in the sense that we're starting to realize that one of the things that feeds mass incarceration and overcriminalization is a lot of features of the system that impel people to plead guilty to big or small cases when they're not guilty. It has to do with looking at bail reform, because one of the things we know that makes innocent people plead guilty, especially in smaller cases, is the fact that they can't make bail. And we also know that bail, of course, disparately affects, by definition, right, people who are indigent and therefore largely communities of color. But we know from the research that if you're held in bail, your trial outcomes are much worse. It makes it much more difficult to prepare a defense if you're locked away in a box somewhere. And so it increases the likelihood of wrongful convictions, even if you have the fortitude to resist the guilty plea and go to trial. So a lot of these things are, again, coming from both this response to mass incarceration and the concern about wrongful convictions. And we are starting to see some people paying attention to it in ways that I hope will bear fruit. But it's not going to be easy because of all the forces we've been discussing that are designed to preserve the status quo.
Okay. Yeah.
Just one other point in all that we haven't really touched on is that there is, a nationwide crisis in indigent defense funding. We have a massively imbalanced, state funding to properly represent people charged with crimes. It's terrible, and we haven't even talked about the role of bad lawyering.
Well, Jarrett
but-
did.
Yeah.
Well, yes, I'm sorry, yes, you did. But, I mean, the sort of systemic nature of that and the difficulty about addressing that, because that requires states to spend money on accused criminals, and that's very hard sell.
And I look, this is what makes no sense to me. So there are people who run for office and they say, will vote for me because I'm going to make the public safe. I'm going to do this. I'm going to do that. And then you lock up everyone for decades, right? Decades. They're in places and conditions where they feed you like an animal, treat you like an animal, you're secluded, isolated like an animal, and then they release you after decades and tell you, now you go be human. So that absolutely makes no sense at all. And so how can that same person who says, vote for me, I'm going to keep you safe, not care about criminal justice reform? Because that is essentially going to keep us safe in our communities. I used to help a lot of people, when I was incarcerated with the legal work, just to pass the time. And I didn't see an act of violence that scared me as worse as the number of people that I saw who pled guilty or were found guilty, not because they were guilty, but because they didn't have resources. And it creates a spiral effect all the way from, they say the school to prison pipeline. No, that's very for real. Like when I got there, I was one of the youngest people in prison at 18 years old. By the time I was 23, half of the prison looked like how I was when I was 18 years old. And then there was people who were coming in there as a result of probations that they violated from juvenile offenses, and then they just graduated to adult correctional facilities. So basically what it's doing is putting and it's keeping certain communities, mainly black and brown communities, in a chokehold. And instead of in other communities where you see people pass down wealth, we're passing down systematic tools to lead you right into prison.
On that happy note, thank you again, all of you, for the work that you do and great questions.